Good morning and good evening. Good morning in Europe and good evening in Oceania, in New Zealand. Today we have a match. This is the second semi-final of the Inter-University Law Debate Tournament 2026 organized by the Corax Foundation. And I give the floor to Miss Lal.
Thank you so much. On today's semifinals match, the two teams will be debating on the topic treaty interpretation should prioritize the object and purpose of the treaty over the subsequent strategic practice of states. We have the University of Bologna from Italy against the Auckland University of Technology from New Zealand. Before we allocate positions, we will get the debaters to introduce themselves. Starting with the University of Bologna, could we hear from Mr. Alessandro Marsh, please?
Yes, good morning and good evening to my colleagues of the opposition. My name is Alessandro Marsh. I'm originally from South Africa, where I did my LLB, specializing in legal philosophy. And now I happen to find myself in a very hot Bologna, where I'm finishing off my master's in legal studies. Thank you.
Thank you so much. From the Auckland University of Technology, could we hear from Mr. Jazz Chadwal, please?
Good morning, everyone. My name is Jazz. I'm a current law student, second-year law student at the Auckland University of Technology, studying a Bachelor of Laws. Really excited for today and all the best.
Thank you. From the University of Bologna, Ms. Maria Soldatelli.
Oh, good morning and good evening to my colleagues at the opposition. My name is Maria Victoria. I'm from Brazil, where I did my bachelor's in law and am currently a bar certified lawyer. I'm currently doing my master's degree in law as my colleague in the University of Bologna, where I'm also a managing editor of the Bologna Law Review. And I wish a pleasant match for all the involved. Thank you very much.
Thank you so much. The final member from the Auckland University of Technology, could we hear from Mr. Tremaine Thompson, please?
Tēnā koutou katoa, ko Tremaine Thompson toku ingoa. Good evening, or good morning to The Hague and to Italy. My name is Tremaine Thompson. I'm a second-year Bachelor of Law student here at the Auckland University of Technology in New Zealand. I'm really looking forward to this match, and I wish my colleagues and the opposition the best of luck.
Thank you so much. And now for the final member from the University of Bologna team, Ms. Ceren Özkan, please.
Good morning and good evening, everyone. I'm Ceren Özcan from Turkey. I did my bachelor's degree in Turkish German University, and now currently I'm conducting my master's degree in University of Bologna in legal studies, and I'm a lawyer back in Turkey. I wish you all a great match today. Thank you so much.
Thank you so much. We would also like to give a special shout out to the coaches and student associations who are supporting both teams. The University of Bologna is supported by Mr. Jose Molinelli, Gulakan Yildic, and Mehmood Berimov. And the Auckland University of Technology is supported by the South Auckland Law Students Association, or SALSA. We will now allocate positions. So if we could please share the screen.
Can I just get confirmation it's visible?
Yeah.
So voice for each team. And for today's debate, it is the University of Bologna that will defend the in favor position and thus argue in favor of the motion and the motion. Thus,
Okay, so that concludes the 5-minute preparation time. Once again, just a quick reminder with reference to timekeeping, please ensure that you can see my screen while you present. When you're presented the yellow card, it means that you have 30 seconds left, and of course, red card means time is up. You may comfortably finish your sentence, but it is not recommended to start another. With that, we will start off with the team in favor. You have 4 minutes for your opening statement, the University of Bologna, whenever you're ready.
Honorable judges, we stand before you to defend the motion. Subsequent state practice is undoubtedly relevant to treaty interpretation, but the question before us does not concern its relevance. The question is whether object and purpose should be prioritized over subsequent state practice, and whether doing so makes treaty interpretation more faithful to the agreement of the parties, the very basis on which treaty obligations arise under the Vienna Convention of the Law of the Treaties. And we believe it does. Our position rests on 3 points. First, object and purpose is the framework through which subsequent practice must be assessed. Second, it protects the categorical minimum of treaties. And third, it prevents subsequent practice from narrowing obligations states accepted. Regarding my first argument, we accept that Article 31 of the VCLT, which establishes the general rule of interpretation of treaties, is not framed as a rigid legal hierarchy. But that does not mean that the order of interpretation is irrelevant. In the preparatory work for the VCLT, the International Law Commission explained in its 1966 draft articles commentary that the starting point of interpretation is the meaning of the text, and that logic required that the ordinary meaning of the terms, in their context and in light of its object and purpose, to be mentioned first. This is why Article 31(1), which codifies this element, is the logical point of departure. By contrast, the subsequent practice under Article 31(3)(b) is taken into account together with the context, and only where it establishes the agreement of the parties regarding interpretation. So we defend a logical point of departure. Subsequent practice assists interpretation within the framework first set by the treaty's terms, context, and object and purpose. Second, prioritizing object and purpose makes treaty interpretation more faithful to the parties' agreement because every treaty has a categorical minimum, the core legal content without which the treaty would cease to be that treaty. The ICJ articulated this logic in the Reservations to the Genocide Convention advisory opinion, holding that states could not be presumed to accept reservations that would sacrifice the very object of the convention. And this was later reflected in Article 19C of the VCLT, which prohibits reservations that are incompatible with the object and purpose of a treaty, because it identifies the treaty's essential legal core. Without it, subsequent practice does not interpret the treaty. It rewrites it through conduct. And this brings me to my final argument. Prioritizing object and purpose prevents states, after concluding a treaty, from strategically using subsequent practice to narrow obligations they accepted. And the VCLT repeatedly treats object and purpose as a legal limit to state conduct. Article 18 prohibits acts which would defeat the object and purpose of a treaty. Article 19C prohibits reservation incompatible with it, and Article 41 restricts later modifications where derogation would be incompatible with the effective execution of that object and purpose. And this logic was applied in the Whaley and the Antarctic case, where the ICJ did not allow Japan's own permitting practice to define the scope of its obligation under Article 8 of the Whaling Convention, but assessed it in light of the convention's object and purpose. To conclude, if object and purpose makes treaty interpretation more faithful to the agreement of the parties, and if the VCLT itself treats it as the logic point of departure for interpretation, how can it not be prioritized over subsequent practice? For these reasons, the motion must stand. Thank you.
Thank you so much. We will now hear the opening statements from the team against the motion, Auckland University of Technology. 4 minutes whenever you're ready.
Thank you. Honourable judges, my learned friends ask who controls the meaning of a treaty. We agree that it is the right question. We simply disagree with their answer. Treaties do not derive meaning solely from what was written decades ago. Treaties derive meaning from the continued agreement and conduct of the states that remain bound by them. That is why the motion should be rejected. Our case rests on 3 propositions. First, the Vienna Convention recognizes subsequent practice as part of the general rule of interpretation. Secondly, the proposition's distinction between practice and strategic practice is legally unsupported and practically unworkable. Thirdly, subsequent practice ensures treaties remain effective and relevant in a changing world. We begin with the Vienna Convention on the Law of Treaties. My learned friends rely heavily upon Article 31.1. So do we. However, Article 31 does not end at paragraph 1. Article 31.3b requires interpreters to take into account any subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. That wording is significant. The drafters did not place subsequent practice within Article 32 as a supplementary means of interpretation. They placed it within the general rule itself. And the reason is straightforward. How states consistently apply a treaty is often the best evidence of what they understand that treaty to mean. The International Law Commission reaffirmed this principle in its 2018 conclusions on subsequent agreements and subsequent practice. Subsequent practice is not an exception to treaty interpretation. It is part of treaty interpretation. The proposition invites this panel to prioritize one part of Article 31 over another. International law instead requires us to regard Article 31 as a whole. This brings me to the central weakness in the proposition's case. The motion does not refer simply to subsequent practice. It refers to subsequent strategic practice. That single word carries much of the proposition's argument. Yet neither the Vienna Convention nor international jurisprudence provides a legal test for identifying what constitutes strategic practice. My learned friends invite this panel to draw a distinction that international law itself does not draw. States negotiate strategically, they litigate strategically, they invoke treaty provisions strategically. Article 31.3b does not ask whether conduct was strategic. It asks whether the conduct establishes agreement regarding interpretation. That is the legal test. My learned friends focus on the motives behind state conduct. The Vienna Convention focuses on its legal significance. This distinction was reflected in the International Court of Justice's decision in the Kasakuli-Sududu Island case. The court examined subsequent conduct because it provided evidence of how the parties themselves understood the treaty. Practice was not replacing consent. Practice was evidence of consent. Who better to explain the meaning of a treaty than the states that negotiated it, ratified it, and continue to apply it? Now, treaties govern a changing world. Technology, environmental challenges, and international relations all evolve. Treaties must be capable of responding to those realities. The proposition's approach risks freezing treaties at the moment of their creation, yet international law has long recognized that treaties must remain effective over time. The Namibia advisory opinion recognized that treaty interpretation cannot be divorced from contemporary circumstances. Subsequent practice performs precisely that function. It allows treaties to remain relevant without requiring constant amendment and renegotiation. That reflects this broader truth that enduring treaties remain effective not because they are frozen in time, but because they continue to operate in the real world. This debate is not about whether object and purpose matters, it plainly does. The real question is whether judges should prioritize abstract purpose over the demonstrated understanding of the treaty parties themselves. We say they should not. Article 31.3b asks a simple question. What have the parties shown us that this treaty means? International law has always treated that answer as important. The proposition asks you to distrust the treaty parties. We ask you to listen to them. For those reasons, we ask you to reject the motion.
Thank you so much. That concludes the introductory statements from both teams. We will now start off with the rebuttal stage, starting with the team in favor. The University of Bologna, you have 2 minutes for your first round of rebuttals.
Honorable judges, my esteemed colleague Mr. Thompson from the opposition has rightly said that the treaty does not ask us to solely look at the object and purpose of a treaty. And we agree, we don't solely look at that at all. But we must keep something in mind. A treaty is a contract. It's a bargain struck between two states which have compromised to reach a specific end or purpose. And thus the object and purpose of a treaty defines the parameters of that bargain. A bargain cannot consist in any case in whichever conduct seems convenient to parties afterwards. And we know, as the opposition has rightly said, that subsequent state action is an invaluable piece of evidence describing the understanding and interpretation of a treaty. But what we're talking about here is a logical order of operations. When we look at the object and purpose of a treaty, what we see is that it provides a benchmark by which to look at these subsequent state actions. And yet when we look at subsequent state actions, we see that it provides no benchmark for the former. And when it's looked at without the former, without the object and purpose, it has the effect of slowly eroding the meanings of these key tenets in the treaties over time. It renders them meaningless, unhelpful, and vulnerable to manipulation, because it starts to pick away at these core commitments within the treaty itself. And this point of view was rightly reflected in whaling in Antarctica, the case which involved Japan attempting to show that its actions there qualified as scientific research. And of course, it pointed to its subsequent state actions under the treaty, which is valid, except that the court rejected them by saying that these actions themselves cannot redefine a treaty. Okay, not simply because it's repeated. In fact, we must look at these actions within the light of the purpose and object. So held the court. Thank you.
Thank you. We will now hear the first round of rebuttals from the team against the motion, Auckland University of Technology. 2 minutes whenever you're ready.
The affirmative in their opening and rebuttal have essentially stated that because Article 31, subsection 1 comes first, there must be prioritization of it. My learned colleague stated a logical order of operations. This is a complete misinterpretation on two grounds. Firstly, the International Law Commission report deliberately rejected a mechanical, step-by-step model of interpretation and instead has emphasized a holistic approach. This is stated as a single combined operation in which all relevant elements are assessed together, not one by one. This design is fundamental and it prevents interpreters from essentially artificially privileging one factor, such as object and purpose, over others, which include subsequent practice or the context or the ordinary meaning. On this new approach from the ILC, Article 31, subsection 1 and subsection 3 are not separate tiers of authority, but are interacting components of the same general rule. Subsequent practice under Article 31, subsection 3 is therefore not secondary or optional consideration. Secondly, honourable judges, there is a logical flaw in the affirmative's approach. If we entertain their narrative, this would mean that the rules of international law are also just permissible and not mandatory, as they are listed in the third subsection. Both interpretation tools are listed there, but because the positioning is less, it means less? No, we completely reject this. Objectively, we understand that international rules are essential to interpretation of treaties.
Thank you so much. We will now hear the second round of rebuttal, starting with the team in favor, University of Bologna. 2 minutes whenever you're ready.
Thank you. Honourable judges, of course we agree that we need to look at these things holistically, and the order in the treaty per se has nothing to do with these logical operations of which we speak and which are mentioned in the preparatory works for the Vienna Convention. But I want to say, first of all, that the fact that we can talk about these intricate issues from opposite sides of the globe is a testament to just how important this legal order is, this international law is. And we can't risk destroying it at all. And destruction wouldn't happen in one fell swoop, but regimes like these tend to crumble when they're slowly eroded by these actions. Okay, so if we look at the scholar Koscomieni, Finnish diplomat and legal scholar, he talks about how subjugating the law to these political actions renders the law itself a vocabulary for power. It mirrors power instead of restraining it. Another key thing to consider is Thomas Frank, a legal scholar from Humboldt, when he says that the law itself draws its legitimacy from the determinacy and consistency of its obligations. Now, these aren't just documents. Behind these laws, there are real people who heavily rely on these definitions and purposes for their protection. Okay, and so we agree completely that subsequent state action is of vital importance. What we're saying is that it needs to be used properly because it is so essential that we use it. It needs to be looked at under the light of the object and purpose of the treaty. And I like the example that my colleague from the opposition made when he mentioned the Namibia advisory opinion. He's absolutely right. The world evolves, law evolves. What we're trying to establish there is the evolved meaning of the object and purpose of those treaties. And yes, absolutely, subsequent state practice was instrumental at arriving at that. But nevertheless, it was that at which we had to arrive. And so I asked the opposition how exactly they will maintain the consistency which is essential to our legal order, and how exactly they can judge the subsequent state actions, if not through the light of the object and purpose. Thank you.
Thank you so much. We will now hear the final rebuttal from the team against the motion, Auckland University of Technology. Your final 2 minutes.
Firstly, my learned colleague has conceded that they agree subsequent practice is vital. And this is, we completely agree with that. They have also conceded that meanings evolve, and yet they want us to look at prior state agreement and prior objectives, which would undermine the current consent of states and the evolved meaning which they have conceded. Treaties derive their legitimacy not from the abstract judicial concept of their purpose, but from sovereign agreement of the states that are bound by them. Subsequent practice is therefore not a threat to treaty interpretation. It is one of the clearest manifestations of the continuing consent. When states consistently apply a treaty in one particular manner, they reveal how they themselves understand the obligations. The affirmative has argued that subsequent practice is vulnerable to strategic manipulation. However, Article 31.3b safeguards that concern. Not every instance qualifies as relevant subsequent practice. International courts have also repeatedly required that such practice be common, consistent, and reflective of the agreement. My learned colleague also mentioned the similarity between a bargain and the law of contract. Precisely, we would agree there and state that even in that case, judges and courts are careful at considering each individual element, and they take a holistic approach when interpreting contracts. So by that logic, they also concede the holistic approach required for treaty interpretation.
Thank you. That marks the end of the rebuttal stage. We will now hear the concluding statements from both universities, starting, of course, with the team in favor. University of Bologna, your final 2 minutes.
Thank you so much. Honorable judges, the esteemed opposition mentioned that we must prioritize real-world practice over abstract formulations. But let us look at what this clash of ideas has truly revealed. We have agreed on one foundational truth today. Both the purpose of a treaty and the subsequent actions of the states are indispensable to international law. We are not here to erase state practices, but we must ask a critical question. If there is no logical order for the operation, what happens when these two elements inevitably conflict? As my colleagues have demonstrated, our position is built on the reality that evidence cannot read itself. If we do not place the object and purpose at the very front of our calculation, we risk the essential core identity that stops the original bargain from being quietly eroded from within. Throughout this round, there has been a strong focus on letting treaties evolve naturally through the shared practice of states. But as we analyze through the whaling and Antarctic dispute, the international legal order functions because state conduct assets interpretation within the framework first set by the treaty's text, not the other way around. If we reverse this order and look at the state behavior first, we do not achieve a realistic balance. Instead, we allow non-compliance to disguise itself as interpretation, turning international law into a vocabulary of power. Honorable judges, we do not ignore the real world. We simply believe you must build the house before you can judge how people live in it. Behind this legal text are real human protections that depends on stable, predictable obligations. A treaty must function as a compass that directs state behavior, not a mirror that shifts political convenience. When purpose and practice collide, the law demands that our values take first place. That is why the motion must stand. Thank you so much.
Thank you. We will now hear the concluding statements for the team against the motion, Auckland University of Technology. You have 2 minutes.
Thank you. Honourable judges, my learned friend's case ultimately depends on a single proposition, that object and purpose sits above every other element of treaty interpretation. The difficulty is that neither the Vienna Convention nor the International Law Commission nor international jurisprudence says that. My learned friends repeatedly invite you to treat Article 31 as a hierarchy. International law treats it as a whole. The International Law Commission rejected a mechanical approach and described Article 31 as a single combined operation. Because my learned friends ask you to elevate one interpretive tool above all others, international law does not. They say subsequent practice is dangerous because states may act strategically, but Article 31(3)(b) already answers that concern. Not every act of a state becomes relevant subsequent practice. Only practice that establishes agreement regarding interpretation carries interpretative weight. A unilateral attempt to avoid obligations is not subsequent practice, it is a breach. My learned friends therefore spends much of this debate attacking a problem that international law has already solved. They say subsequent practice threatens consent. We say subsequent practice is evidence of continuing consent. The question is whether the treaty parties demonstrated a common understanding of what the treaty means. That is precisely why the International Court of Justice examined subsequent conduct in the Kasakali-Sadudu Island case. Practice was not replacing consent, practice was evidence of consent. And that is where my learned friend's case ultimately fails. They would have judges prioritize an abstract conception of purpose over the demonstrated understanding of the treaty parties themselves. But treaties derive legitimacy from states. The treaty parties are the masters of their agreement. Honourable judges, this debate comes down to a simple choice. Do we interpret treaties through the demonstrated understanding of the parties themselves, or do we elevate one interpretative tool above all others? We say the Vienna Convention gives a clear answer. Treaty interpretation is holistic, not hierarchical. My learned friends ask you to trust an abstract purpose over the conduct of the treaty parties themselves. We ask you to listen to the parties. After all, if the parties themselves cannot explain what their treaty means, who can? For those reasons, we ask you to reject the motion. Ngā mihi, thank you.
Thank you so much. That concludes our second semi-final match for the tournament between the Auckland University of Technology from New Zealand and the University of Bologna from Italy. As always, you're no longer assessed from this point onwards. And great job to both teams. You both did very well. And once again, congratulations on making it this far and for the next matches. My colleague Mario will now go take over and will lead the feedback and networking portion of the match. Good job once again, and all the best to both teams.
Thank you. First of all, congratulations on reaching the semifinals, and congratulations again for today's match. I hope that you are proud of your performance. And, well, as usual, we would like to gather your feedback on the topic research and the match itself. So I will first give the floor to Mr. Marsh.
Thank you so much, and thank you to my colleagues for the opposition. I really enjoyed that. The topic itself was incredibly interesting, if not purely for its very logical nature. It seemed like a really legalistic question, and that was quite a surprising change from some of the other topics, which have tended to rest a lot upon world events, how these things happen in practice. And this week, we got the opportunity to go right to the core of the question. Preparing both sides seemed to lead to more and more new avenues. And it was really interesting to see that the opposition, of course, had also explored those very same avenues, even ones I thought were so unique that we were special. They had used them as well. And so that was a really good match, really good topic, and really good performance by the other team.
Thank you very much. Now I will give the floor to Mr. Chatwal.
Similarly, as my colleague has stated, researching this topic was interesting. From a New Zealand perspective, our country's foundational document is a treaty, so it really goes at the core of what we learn here at law school. Is various different interpretations, and specifically domestic treaty law. So similar imputations with international treaty law as well. Overall, I found this topic interesting and exciting, and like my colleague stated, very legalistic, very nitty gritty, based on the wording of provisions and the order, etc., like that. So yeah.
Thank you very much. Now I will give the floor to Ms. Soldatelli.
Thank you very much. I would have to say that this was my favorite topic, to be honest, because I do love legal philosophy and legal theory. And I would say that this was a matter of philosophical exercise in law. Like, how do we interpret these things? There's no obvious reason. There are many different ways that you can try to defend this, both sides, of course. And but I do believe that we were able to present it in the best form ever, and I also believe that the opposition did the same. It was really interesting to see how you argue for this, and even how some of the arguments that we prepare for our opposition, if it happened, also appeared in your own speech. So it's interesting to see how we tend to think alike in this legal questions, you know. But anyway, it was really brilliant. And the match, of course, was amazing. Thank you so much.
Thank you very much. Now I will give the floor to Mr. Thompson.
Thank you. Yeah, I would just like to echo what the previous three speakers have said. I think, this was a really good debate, and I particularly enjoyed the performance of I would say the Italian team, but none of you are actually Italian, so that doesn't really seem to fit very well. But I thought it was really good, very well performed. Like Jazz said, here in New Zealand, we don't have a codified constitution. We have the Treaty of Waitangi and multiple parts of legislation that makes up kind of our constitution. And the Treaty of Waitangi is something that is often debated. Just recently, there was quite a big controversial debate around the principles of that treaty, and interestingly, how that treaty is interpreted in today's world. So we were drawing on a lot of that kind of domestic knowledge and applying it in our thinking today. Thank you once again to COREX Foundation and to our opponents for such a great match.
Thank you very much. And last, I will give the floor to Ms. Ochan.
Thank you so much. Congratulations to both teams, let's say. I find the motion different than the others that we did our matches before. They were more specific and technical before, and this motion is more regarding to the legal philosophy, and it was requiring a lot of readings, starting for the articles, see the philosophical background of the motion. I found it harder, actually, contradicting with my teammates, but I found it harder because I'm coming from a background that I have interest in personal data protection, AI, and this kind of digital law matters. This was more philosophical for me, but it was a lot of pleasure during the match. It was a great experience. I wish the best.
Thank you very much. And before proceeding to the networking question, if Mr. Molinelli wishes to share his thoughts regarding both teams, you're welcome to do so.
Of course, thank you so much, and salutations to the opposing team. You've done a wonderful and a very impressive job. Last year, me and my colleagues, we had the honor of going through the entire competition. I have to say that your performance is truly outstanding, and I'm very happy for the performance of my team as well. And making a clarification regarding Mr. Thompson's comments is yes, none of us are Italian. Three of us do have Italian heritage, and Jaden has an Italian boyfriend, so I guess we're as close as can come. But in a way, yes, it was a very impressive match, and I really look forward to seeing not just the progression in the competition, but also what all of you do in your definite, really bright careers approaching. So, congratulations to all.
Thank you very much. And once again, thank you for sharing your thoughts on today's match. So now we will proceed to the networking question. So in 1 or 2 sentences, who would you like to thank for supporting your journey in this competition? And why has that support been meaningful? So for this question, I will first give the floor to the team of the University of Bologna.
All right, I think if I can go, I can say very easily to answer. The biggest support during this competition has without a shadow of a doubt been our coach, Jose, and our other 2 coaches. They've been, you don't realize how busy these guys are, and they're always there to help. And of course, to my teammates who will stay up at all hours of the night or any time of day in order to meet with you, reassure you, and help you get through the preparation. So thank you guys for the support.
I think I can go then. I would say it's the same thing. Our coaches have been absolutely amazing during all the competition. Like we could not do this without them, and I say this with all my heart. And same goes for my colleagues. They have been so incredible and supportive, and going through this process beside them has been a wonderful experience. So I only have to thank them, all of them, very much.
Guys, don't make me cry for my teammates. And thank you so much to our coaches as well. I agree with both of my teammates. It was a great experience, and our coaches helped us, motivated us, supported us more than one time. I'm glad that I had the chance to work with them, and it's a great opportunity again to experience. Thank you.
Thank you very much for sharing your answers. And now I will give the floor to the team of the Auckland University of Technology.
I'll struggle to do it in 2 sentences, but I'd like to thank first and foremost my teammate, Tremaine. We have spent long nights, sleepless nights, preparing for plenty of the debates, as my learned friends would understand also. So big thank you to my teammate, first of all. Big thank you to the law faculty here at AUT, specifically our Dean, Professor Kylie Quince. She's been amazing support, motivation, and helped organize various different things for us. For me personally, I'd like to thank my family, of course, and my partner for pushing me to reach excellence, and really go for it, and never to settle, I guess, and give my full potential.
That was me, sorry. Well, firstly, thank you to my family, and also the law faculty. Thank you also to the Corex Foundation for organizing this tournament, and also to everyone who has supported and donated. We've been, this last 2 weeks, we've been very quickly raising funds to cover the costs for us to be coming to The Hague next week. And so massive shout out to everyone who has helped us there. But most importantly, just a few weeks ago, my father was actually killed in a car accident. And in one of life's strange moments, Jazz and I found out that we had qualified for these semifinals on the very day of Dad's funeral. So the last few weeks have been some of the hardest of my life. And through it all, I've had one real constant beside me, and that's Jazz. He's carried far more than his share of the load, supported me when I needed it most, and been the kind of friend that everyone really hopes that they'll have when life falls apart. People will probably see two teammates standing here tonight, but really I see a brother. And in a few days, we'll be standing together in The Hague, representing not just ourselves, but for the first time in history, New Zealand. And I honestly cannot imagine making that journey with anyone else. So thank you, Jazz.
Thank you very much for your answers. And once again, thank you very much for today's match. We hope that you will keep in contact for future opportunities. And in order to conclude today's session, I will give the floor back to Ms. Urbanova.
Thank you very much. It's been an honor to see your journey from the very beginning up until today, and soon in The Hague, either in person or in virtual format, as you can travel. And you have all had challenging times, and to whatever part we have played to support you as well, or to motivate you for your next journey or the journey you're currently on, it's been an honor, and it will continue to be one as we see you progress, as we see you in the next editions or in your professional careers. And on that note, to Professor Lorange.
Yes, first of all, congratulations for this match, for this session. That was very, very good to see, as well as the experience you capitalized for all the match you got. That was the 6th match for each of you in this competition, and next week will be the 7th one. So it means as soon as we have the results, we'll share with you, of course. But we'll be happy as well to meet you in person. That is something we're very looking for. As well, you meet more than just us, but as well some judge, and we prepare a lot of things. Having in mind that, of course, yesterday there was as well the match, the other semi-final. So in general, yeah, the final is a moment of networking, of celebration of all your achievements. And I can tell you that we have many things as well we prepared as well for next week. So we'll be happy to welcome the Bologna team and the Auckland team next week in The Hague. Of course, please take care of yourself next days, of course, to be ready and prepared to have the last match, grand final or match for the third place. And on our side, yes, we'll be there. At this moment it's raining, but next week I hope you will have a better weather than the typically Dutch weather. So voilà. So thank you again. So wish a great rest of the day in Italy, great evening and night in New Zealand, and we'll keep in touch for the next days. And remember, Friday we send the topic for the finals, and I mean the 2 match. So thank you again, and see you soon. Thank you.